the question is not, are the judges doing what you'd like them to do? The question is, are they doing what the law and the Constitution require them to do?
In September of 1787, after long months of debate and disagreement, the delegates of the Constitutional Congress met at the State House in Philadelphia and signed the Constitution. In the effort to balance state sovereignty and federal power, nearly every delegate had compromised beyond expectation. George Washington referred to the accomplishment as little short of a miracle. The document gave form to the new government, dividing power into three branches.
The Constitution purposely divides the functions of government, and both the state constitutions of every state and the federal Constitution. And those functions are divided in order to protect our freedom. We don't want one branch of government doing the work of another branch, because as they do, they're accumulating power. So we want to separate those functions. And it's a constitutional doctrine. The Constitution requires that.
Article 3 established the judicial branch, empowering the courts to try cases with certain limits on its authority.
The legislature makes the law. The executive executes the law, and then that law is interpreted and enforced ultimately by the judiciary.
The court's job is to follow the law and to follow the Constitution. And it may be that that produces outcomes that people unaware of that template find offensive.
People look at it and they say, well, I don't like that outcome. If I'd been a judge, I would have done it a different way. But I trust that if that person had been a judge, that person would have looked first to the Constitution.
In 1947, in an article on the Supreme Court, historian Arthur Schlesinger, Jr. characterized the alliances and divisions among the justices as judicial activists on one side and champions of self-restraint on the other. These new terms took root and, in one form or another, continue to define the issue.
A judicial activist is a believer in a very enhanced role for the judiciary in making public policy in the polity. That the judge gets to second guess what the legislature has done. So if the legislature passes a statute and says that to get this benefit you have to make application within 30 days, well, maybe 30 days is 30 days, but maybe it isn't.
And the Constitution allows the legislature to do dumb things and smart things. It doesn't distinguish. It gives the legislature power to decide, to make policy. It's our job to carry forward that policy.
Your gut tells you, come on, give the guy the extra day. But your discipline as a judge says you shouldn't. I think the judicial conservative says 30 days means 30 days. The judicial activist, or judicial supremacist, as I think they're sometimes called, says, no, give him 31.
A judicial activist is one whose judicial philosophy is that his job is to do what is right. A judicial conservative would view his job as to do what the Constitution and the law requires.
So ours is sometimes a tough road to hoe with making the public understand why you're doing what you're doing. But if you explain it adequately, I think they do understand it, and they do come to understand the difference between being a judge and being a legislator.